Let me go over some quick instructions on how to use the webinar system. For questions, please use the Questions tab or menu bar item located on the GoToWebinar menu on the right side of your screen to submit questions, as all lines have been placed on mute. For handouts, to get a copy of today's presentation, select Handouts on the GoToWebinar tab or menu and follow the instructions. Handouts will also be included in the automated webinar follow-up email sent within 48 hours of this event. And for CEUs, today's webinar has been approved for 1.2 hours from the Healthcare Compliance Association. An email with the survey and download instructions will be sent within 48 hours of the webinar. And with that out of the way, I'm extremely pleased to welcome Robert Roth, Katrina Pagonis, and Felicia Thie from Hooper Lundy & Bookman. Robert Roth is a managing partner at Hooper Lundy & Bookman's Washington, D.C. office, advising clients on matters arising under Medicare and Medicaid, focusing on payment, compliance, and licensing issues. A former senior attorney for CMS and former assistant attorney general for the state of Maryland, Mr. Roth represents a wide range of clients on federal and state regulatory and business matters, and is also one of the select few health lawyers to have argued before the U.S. Supreme Court, which he did in Sibelius v. Auburn Regional Medical Center. Katrina Pagonis' practice focuses on the representation of healthcare providers in matters relating to healthcare reform, as well as regulatory compliance more generally. She advises clients related to the Affordable Care Act and health insurance exchanges, and her regulatory work covers issues in fraud and abuse, nonprofit law, clinical trial agreements, and privacy and licensure. Felicia Thie is also a partner at Hooper Lundy & Bookman out of its San Francisco office. She advises healthcare providers on a myriad of Medicaid and Medicare reimbursement matters, focusing on both the managed care and fee-for-service programs. I'd like to welcome you all today, and with that, I'd like to turn it over to Mr. Robert Roth. Go ahead.
Hey, thanks, Jenny, and hello, everybody, and thank you for joining us. I'm so pleased to be speaking today with my two expert colleagues, with Katrina and Felicia. The 60-day report and return statute has been on the books since, actually yesterday was the 6th anniversary, since March 23rd, 2010. And it's actually been a nightmare of providers since that time because of two things: the numerous uncertainties that arise from the efforts that are made to apply this statute and the severe penalties that occur when there's a violation of the statute. It's taken 2 years for CMS to issue the proposed rule, 4 years for it to go final, but we now have the final rule. And to CMS's credit, they addressed a lot of the uncertainties in the statute in the final rule. However, the final rule also contains new uncertainties. And so we have some uncertainties that are left over from the statute itself, and then the uncertainties that arise from the final rule. So what we want to do is walk through this final rule today, and give you an idea of what these uncertainties are, and where we can give you some practical thoughts about how you may be able to deal with these. We're going to be gearing our talk today to providers, and when we use providers, we also include suppliers under Part B as well. We're going to try to address the questions that come up on our screen along the way, but we may not be able to, and we'll probably hold them until the end because we do have a lot to cover. Next slide. So we have our standard disclaimer that these are our views and not the views of our firm or of any of our clients. Next slide. Here's what we're going to be covering today. And remember, the final rule is limited to Medicare parts A and B. The statute itself applies to both Medicare and Medicaid. Felicia's going to talk about Medicaid at the end. But this final rule addresses A and B, and a previous final rule addressed C. So Medicaid is currently unaddressed in rulemaking by the agency. So what we're going to cover today is first an overview of the report and return obligations under the statute. Then we're going to talk about the identification, this crucial term of identifying overpayments, and this new phrase that came out of the final rule, reasonable diligence. The final rule has a 6-month benchmark to complete investigations and to make refunds. We'll talk about the 6-year look-back period and CMS's position about using underpayments. We're going to talk about this new requirement for providers to be proactive with their compliance activities. We're going to address the cost report issues in the final rule, the report and return mechanics, the implications for Stark disclosures, and then, of course, as I said, Felicia will address these open questions about Medicaid overpayments. There are 4 basic takeaways that we think you ought to keep in mind as you listen to our webinar today. First is that the buck for the return of overpayments stops with providers. Providers may not have created the overpayment. It may have been the fault of a contractor. It may have been the fault of the government itself. It may have been years and years and years before the providers even learned about it, but providers are on the hook for refunding and reporting overpayments. Second, we have long said that providers needed to operationalize the investigation and refund requirements and make that a regular part of operations within the provider. Now the final rule gives new guidance, additional guidance that providers need to take into account with respect to their compliance efforts. Third, the final rule contains many vague terms like reasonable diligence, like proactive, that we're going to be discussing. And CMS has said that the purpose of those vague terms is to allow CMS to determine over time how to refine those definitions. That time for refinement is going to be a time of risk for providers because whatever vagueness or uncertainty there is, providers are going to have to figure out how to react, and of course they have the False Claims Act bar looking over their shoulder for whatever they decide. Finally, the preamble to the final rule is 30 pages long in the Federal Register. The changes to the regs are all of less than a page, but there's 29 pages of preamble language, and the preamble includes many lines that we typically think of as throwaways, not here. That information that's in the final rule but in the preamble is extraordinarily important, and it's important for providers to be aware of what's in the preamble. Now, this final rule has been 6 years in the making. The statute was issued, was enacted on March 23, 2010. It was 2 years later before the AB proposed rule came out. Then the CD proposed rule came out. The CD final rule was issued. And then a year ago, CMS said, you know what, we're going to need another year before we could finalize AB, and AB finally comes out. So the point is to say that this is an acknowledgement by CMS that this is a complicated statute. Next slide. So how did we get here? Well, we actually got here. Here's the provisions of the statute. And we have to actually go back before 2010 to 2009 in the Fraud Enforcement and Recovery Act, in FERA. In that law, Congress addressed what's called the Reverse False Claims Act, not where the government makes payment on a false claim, but where a person retains funds where there's an obligation to refund. And so what happened is that law came out in 2009, and one of the anomalies in the Medicare Act is there had never been a clear obligation to refund. And so what this law did in 2010 is it did 2 things. Number 1, it established a clear obligation to refund. And number 2, more importantly for our purposes, it established the time limit for which that would be done. And so what this statute says in the underlying language, if a person receives an overpayment, they have to report and return the overpayment. And the next section says, and that needs to be done within 60 days after the date on which the overpayment was identified, or the date of any cost report. Now, of course, the cost report might not be due for a year or so later, but what CMS has stated, and we'll get into this, the cost report delay exception is rather narrow. So generally, we're talking about 60 days after the date on which is identified. In the next section here, you see that they now cross-reference it back to the FERA provision by saying that any overpayment retained beyond that deadline is an obligation for False Claims Act purposes. And definitionally, we have overpayment as being identified as this is a crucial thing, as funds to which the individual is not entitled to after reconciliation, after this applicable reconciliation. And as we're going to see, this concept of applicable reconciliation, which delays the actual realization of an overpayment, has been extraordinarily narrowly construed by the agency. Okay, next slide. In addition, crucially, in addition to the False Claims Act exposure, the statute itself will also expose a provider to administrative action by the agency, typically by the Inspector General's office, to impose a civil monetary penalty if a provider knows of an overpayment and doesn't report it and return it in accordance with the 60-day statute, which includes penalties up to $10,000 per item of service and 3 times the amount claimed, and potential program exclusion. So that in addition to whatever exposure there is from the False Claims Act bar, the government has its own administrative sanctions and administrative enforcement tool and tremendous leverage over providers that don't comply with the report and return requirement. Next slide. As we said, this final rule addresses only A and B. And it went into effect on March 14th, 2016. What happened before that? Well, CMS has long held the position that the requirements of this statute are self-implementing. So they went into effect as of March 23rd, 2010. So what happens before the period of March 14, 2016? And here's another one of those vague terms. CMS goes and said, well, providers are expected to have made good faith compliance with the statute. What does good faith mean? Well, who knows, but the government knows it when it sees it. But this is another one. I mean, it's already happened, so whatever happened, happened. But the articulation of good faith compliance will be important for any issues that come up with respect to the period before March 14th, 2016. And with that, let me hand it over to Katrina.
Thank you so much, Bob. So moving to the text of the regulation starts out with an articulation of the provider's basic obligation to report and return overpayments, and it does so in a way that largely echoes the statutory language. But this obligation to report and return overpayments brings us back to that basic question that's only partially answered by the statute of what is an overpayment. And the regulation pulls again from the statutory language here because it's a Part A-B, Medicare Part A-B regulation. It just references Title 18 of the Social Security Act and doesn't reference Title 19 on Medicaid. But other than that, it very closely tracks the language of the underlying statute. But when we move from that one page of regulations in the Federal Register to the 29 pages of explanations, we get a little bit more depth in terms of what constitutes an overpayment. And CMS makes it clear that the fault for an overpayment does not matter. If an overpayment is not caused by a provider, if it's the fault of a MAC or an edit problem or something else, the provider still has that obligation once they identify the overpayment to report and return under the 60-day rule. And in the preambular language, the CMS also clarifies that the statute and regulations only address overpayments and do not address underpayments, asserting that because underpayments are not covered by the statute, the provider cannot offset their overpayment refund with underpayments or payments that they were owed and did not receive. Oftentimes when providers undertake audits, they do discover both overpayments and underpayments. And CMS has set a strict line here that underpayments can't be offset, at least through that preamble language. CMS also provided examples of overpayments, and a lot of these were echoes from the proposed rule issued back in 2012. But in the preamble, they also talk about insufficient documentation and lack of medical necessity as potential issues that could produce overpayments. Commenters had noted that there's an element of subjectivity in determining when documentation is sufficient for a claim or when services are medically necessary. But CMS replied saying that sufficient documentation and medical necessity are long-standing and fundamental prerequisites to Medicare coverage and payment, and therefore claims submitted without these requirements could produce overpayments subject to the 60-day rule. Now, the statute's obligation is to report and return the overpayment by the later of 60 days after the date the overpayment is identified or the date any corresponding cost report is due. The statutory language itself is unforgiving once identification occurs, and we're going to talk about pinpointing when identification occurs in a moment. But once that occurs, the 60-day clock starts ticking, or the date any corresponding cost report is due, if after that date of identification would start the clock. And the statute doesn't provide anything that stops that clock. But the regulations do adopt certain circumstances that would suspend that 60-day deadline. First is the OIG self-disclosure protocol or submissions to CMS's self-referral disclosure protocol. When a provider makes a submission under either protocol, the 60-day clock is suspended until the issue is settled with the OIG or CMS, or the disclosing party withdraws, or they're removed from the protocol. If there's withdrawal or termination from either protocol, then the balance of the 60 days that are left would start ticking, and the provider would have that time to report and return the identified overpayment. So if at the point of identification the provider initiates the protocol, say 10 days after identification, then on withdrawal from the protocol they would have the remaining 50 days to complete the overpayment. Disclosures to the Department of Justice or the Medicaid Fraud Control Unit do not suspend the deadline. The regulation also includes a payment plan allowance, which was not present in the initial proposed rule back in 2012. So a provider can request a payment allowance and thereby suspend the repayment obligation. Interestingly, the regulations, the rule text itself only includes these examples as suspending the repayment obligation in the 60 days. But in the text of the rule, CMS clarifies that there are other situations where they want providers to wait. For example, if a provider does a probe sample, CMS doesn't want repayment based on that probe. CMS wants the extrapolation from the probe to the universe of claims, and then from that point of identification for the universe of claims, the full report and repayment, rather than a two-step process of reporting repayment based on the probe and then based on the extrapolation. Likewise, repayments allowed through the credit balance process, and commenters noted that through that credit balance process, it's due 30 days after the end of each quarter, and CMS says, you know, that's fine. You just you can use the credit balance process, and suggesting that even if that pushes out past 60 days, that process could be analogous to a suspension of the deadline. But again, this is relying on the preambular language rather than the text of the rule itself. So this moves us to the meatier topic for the 60-day report and return rule. When have claims been identified? And what are the provider's obligations to identify claims? Like the proposed rule, identification here is both the actual identification or a provider that should have identified the overpayment. And this final rule uses the term reasonable diligence as a benchmark for what the provider's obligations are to investigate and identify overpayment. The regulation also clarifies that a provider should have identified an overpayment with reasonable diligence if the person fails to exercise reasonable diligence and that person in fact received an overpayment. So this means that it isn't a question of when the provider would have discovered the overpayment with reasonable diligence. Instead, it seems to focus on the absence of reasonable diligence and the receipt of an overpayment as triggering the obligation and triggering identification. The other interesting thing about this definition of identification is that CMS explicitly includes quantification of the amount of the overpayment as part of the identification process. In the proposed rule, it wasn't clear whether a provider's investigation included that time to quantify, and that confusion contributed to a significant amount of difficulties on the provider end. Now, that obligation to exercise reasonable diligence in identifying claims it takes up a significant portion of the preambular language. CMS specifies that this reasonable diligence requirement has two elements to it. Both proactive compliance and a reactive investigation are components of reasonable diligence. And my colleague Felicia is going to be talking a lot about those reactive investigations. But it is worth taking a moment to focus on that proactive compliance obligation, which is wholly new to the preamble to the final rule. This isn't something that was really discussed, at least at this level of detail, in the 2012 proposed rule. And CMS is here stating that that both that proactive and reactive compliance are required, and the failure to exercise either could be a default in the exercise of reasonable diligence, triggering potential exposure for the provider. So what does proactive compliance entail? You know, CMS here says that all providers and suppliers need to undertake proactive compliance, and a provider that undertakes no or minimal compliance activities to monitor the accuracy and appropriateness of a provider or supplier's claims would be exposed to potential liability. There are portions of the rule that do mention that the type of provider or size of the provider would be informative in determining what level of proactive compliance activities are appropriate to that provider. But each provider in CMS's view is obligated to have some sort of proactive compliance activities. And this notion raises some very troubling questions for providers seeking to abide by the report and return rule. It's a very vague standard dictated by facts and circumstances found in a preamble to a rule. It's unclear what a provider needs to do in order to be assured of full compliance. And if a provider does not, but arguably could have discovered an overpayment by being proactive, we don't know whether that provider and when that provider has identified the overpayment. You know, is this a negligence standard, a gross negligence standard? At what point is a default in proactive compliance sufficient to trigger a view that there's been an absence of reasonable diligence such that the overpayment's been identified? And when would that 60-day deadline commence for that provider? And you know, how is this going to impact the adequacy of providers' compliance efforts in litigation? Are there going to be key TAM relators now looking over providers' shoulders who tie their claims back to an argument that there wasn't any defect in the provider's response, but the provider didn't have adequate proactive compliance in place and therefore is liable for the failure to return an overpayment? Now I'm going to hand off to Felicia, who's going to talk more about the investigation side of things.
So in addition to the proactive obligations, and thank you, Katrina, there is there is now more clearly a reactive obligation to respond to credible information that is received by the provider. The CMS describes credible information as information that supports a reasonable belief that an overpayment may have been received. The rest of this slide and the next slide go through various examples of what could be considered, what CMS has described as credible information. And while most of these, some of these, you know, for example, where patient death occurred prior to service date on a claim submitted for payment appears fairly clear, there could be other issues where, for example, where an internal audit reveals overpayments. A lot of times that finding might be an issue where the provider's first initial reaction is that they suspect there might be an overpayment, but sometimes upon further investigation they may discover that that is not actually the case. But either way, once you have that trigger of that there's a good suspicion of an overpayment that would constitute credible information that should trigger a reasonably diligent inquiry. So among the things that CMS clarified would constitute credible information, it received a question in the final rule asking whether, what extent an increase in Medicare revenue could be credible information of an overpayment, especially when you're talking about a provider such as a clinical lab or other provider that does not actually order tests or services. At the point when their Medicare volume goes up, do they have an obligation to investigate? And CMS clearly responded that yes, even though that provider doesn't have control over what kinds of orders come in that it's going to fulfill, if it notices that its Medicare volume goes up and its Medicare revenues increase, it does have that would constitute credible information that should trigger a reasonably diligent inquiry. At that point, CMS stops, but we still have that question as to, at that point, you look at if you're a clinical lab and you receive higher Medicare reimbursement than you have in the past, what exactly do you investigate? Is the lab expected to go out and reach out to every physician that ordered a test in order to confirm that those services were actually rendered, or what exactly do we do? And I think that's one of the things that we're going to be exploring more as the longer that we are living with this rule. Now we go to the next touchstone, which really is that there is only liability if there is actually an overpayment. So in this regard, failure to exercise reasonable diligence does not create liability unless there is an overpayment. But even though that many providers might suspect, oh, we probably don't have an overpayment because we did actually, in good faith, provide services, and so despite whatever report, documentation issues or otherwise, they might rely on that for the proposition that they don't have an overpayment. We think that that's a really risky position to take in light of this new AB rule, because if you are ignoring credible information of a potential overpayment, really on the basis that you believe that there was no overpayment, to the extent that there might have been an overpayment, then that would constitute the lack of reasonable diligence in the light of credible information. Now, the next issue that came up, this is one of the few highlights of the rule for providers. It gives providers a little bit of breathing room because prior to this final rule, the proposed rule and then other sources suggested that the identification really was triggered, and this was the case in the King case, the Southern District of New York, was that identification was triggered once you had a reasonable suspicion that you might have an overpayment, and that triggered then the obligation to identify and quantify the overpayment within the 60 days. Well, the final rule makes it very clear that that is not actually the case. It provided a 6-month benchmark within which providers are expected to perform reasonable diligence. And in that 6 months, they provided 6 months from the receipt of credible information for the provider to investigate and to quantify the amount of any potential overpayment. So in all, providers have a total of 8 months, 6 months to investigate once they have received credible information, and another 60 days to report and return. But either way, they have to act both with reasonable speed and, I would say, reasonable diligence. Now, there is an exception to the 6 months, and that would be extraordinary circumstances. From the looks of the final rule concedes that in extraordinary circumstances, the investigation might go beyond the 6-month benchmark that CMS identifies. However, the facts, it's very fact-specific, and in the perambulatory language of the final rule, the situations that could give rise to extraordinary circumstances seem to be pretty narrow. Some examples are unusually complex investigations that the provider reasonably anticipates will require more than 6 months. For example, a stark violation that's reported under the SRDP. Other examples include natural disasters or state of emergency. We can imagine that there might be other situations, for example, where a methodology or legal interpretation of a statute or regulation is still unclear, and you're waiting for clarification from the agency in order to determine, what methodology should be applied, until you get that information, it's hard to identify for yourself whether or not there is an overpayment. Or a situation where you might require a review of numerous medical records and you have to look chart by chart, for example, for a medical necessity issue, that could also, we think, potentially constitute extraordinary circumstances that would allow a provider to go past the 6-month benchmark for their investigation into an overpayment. So one of the other issues that CMS clarified in the final rule is that ultimately an organization will be deemed to have received credible information if anybody within the organization has received that information. CMS explicitly rejected the idea that it must be a senior official in the organization who received the credible information, and stated that organizations are responsible for the activities of their employees and agents at all levels. So the question then is, when does the 6 months begin? That becomes very difficult, because a lot of times where somebody who might be at the lower levels of the organizations becomes aware of an issue, that doesn't always trickle up to individuals who have the authority to be able to initiate a reasonably diligent inquiry. And so this becomes part of that proactive compliance issue, where there needs to be some sort of policy. There likely should be some sort of policy that emphasizes to employees the importance of promptly reporting any credible information of overpayments internally to the appropriate people. Another issue that was raised by CMS I skipped a couple of slides. So this is the crucial rule of when the 60-day period begins. The 60-day period begins, number one, if the provider receives credible information, an overpayment may exist, and fails to exercise reasonable diligence to determine if there is an overpayment. The 60-day period begins when the provider receives the credible information. On the other hand, if the provider receives credible information and exercises reasonable diligence that there's an overpayment, then the 60-day period begins when the reasonable diligence is completed. To the extent that a provider might have exercised reasonable diligence and then ceases to do so, so actively investigates for a month and then puts it on the back burner for 3 months, it's very likely that the 60-day period will have started when that reasonable diligence, when they cease exercising reasonable diligence. As I mentioned before, one of the other benefits is that that 6-month period would include quantification of the amount of the overpayment. So the 60-day does not begin until the overpayment is quantified, or should have been quantified upon exercise of reasonable diligence. There were some commenters who requested that CMS adopt a minimum materiality threshold. A lot of providers receiving, 5-cent, 10-cent overpayments, $1, and CMS declined to adopt a materiality threshold based on the language of the statute, and it specifically stated that its rationale for that was because you could have a large number of very small amount overpayments that, when added up, could be a significant amount. Now, the next issue that CMS addressed was duplicative audits by contractors. There was some real concern about whether or not the repaid claims would be involved in a RAC, MAC, or OIG audit, and CMS had provided, assurance that they would not recover an overpayment twice. I'm going to go on to the next slide. So one of the other issues is what happens when a provider receives notice of a contractor or government audit. Now, this really changes with respect to government and contractor audits. There is an established process by which those go, but this now complicates that process because the 60-day rule may now give rise to report and return obligations if a provider does not disagree with the results. So, for example, if you receive an inquiry with respect to a billing practice and you look into it and you notice that, yes, indeed, there was an issue, that might independently trigger report and return obligations before there are final findings on that particular issue. In addition to that, that might actually broaden the scope beyond the audit period that was requested by the government or contractor to review similar items that might be outside of the time period of the audit. So if you have that erroneous billing practice and you realize that that would have been an issue perhaps before that period that was being audited, then that would constitute credible information that the provider should probably be going back and looking back to identify how far back that problem might have existed. At the same time, there are times where the government or contractors come in and audit and the provider simply doesn't agree. And if that's the case, then if it's going to, for example, appeal the audit, the provider may reasonably assess it is premature to investigate nearly identical conduct for the additional time period until the appeal is concluded. And certainly at that point would be able to, would reason that its obligation to exercise reasonable diligence investigating potential overpayments has not been triggered because they still disagree with the underlying theory that might give rise to an overpayment. At some point, that appeal process will end and there is some finality to the government or the contractor's position. And at that point, it is, for example, if you get a court opinion, an adverse court opinion, at that point, we think that it's probably likely that there would be a credible information of an overpayment. Okay, next slide. CMS also provided further clarification on how to address anti-kickback violations. Importantly, with respect to providers that are party to an arrangement, there appears to have a duty to investigate, report, and return. CMS appears to view anti-kickback violations as giving rise to overpayments, but that raises a number of questions as to whether there is sufficient scienter for a violation. At the same time, going to the next slide, CMS clarified that where a provider is not a party to the anti-kickback violation, it might not have, if it doesn't have credible information, sufficient knowledge of the arrangement to have identified the overpayment, their obligation to report and return has not yet been triggered. But when the provider does receive sufficient knowledge of the arrangement to have identified the overpayment, at that point the provider must report, but not necessarily return, to CMS. CMS will then refer the report to OIG and suspend repayment obligation until the issue is resolved through the OIG. The expectation by CMS is that parties to the arrangement, not the provider, would be required to make any repayment except in extraordinary circumstances. Another issue, and this kind of goes in line with the employee and agent standard that I mentioned previously, is that CMS has clarified that the provider is responsible for overpayments resulting from actions of their agents, including billing companies. It responded to a concern about identity theft and where there may have been claims submitted, but because somebody had stolen the provider's identity. CMS's advice there was to report the identity theft to law enforcement and CMS, and then wait for instructions from CMS regarding overpayment. With respect to the increased obligations and the tying of the 60-day obligation to whether or not reasonable diligence was actually exercised, documentation becomes very important. And CMS, in the perambulatory language, states that it's certainly advisable for providers and suppliers to maintain records that accurately document the reasonable diligence efforts to be able to demonstrate the compliance with the rule. So these are some examples of documentation so that if it were to come up, for example, in the false claims context, the provider would have sufficient evidence to demonstrate its continued reasonable diligence. Now I think it goes back to Bob.
Thanks, Felicia. Yeah, so I've got a kind of a hodgepodge of issues that I'm going to be addressing here. A question came in about what the difference is between a credit balance on the 838 form and an overpayment. And I think a credit balance is an overpayment, but what's different is that the regulation text recognizes that the credit balance reporting program is a process that can be used, even though it could result in overpayments being reported, at least this type of overpayment is being reported after the 60 days. It's addressed in the preamble. Waiver of liability. Under waiver of liability, a provider will not have to repay, will not have an overpayment on a medical necessity issue if it's determined that the hospital, the provider, did not know or could not reasonably have been expected to know that the services would not be medically necessary. Historically, this has been a defense. In other words, the government asks for a refund of the claim, and the provider said, on the basis of lack of medical necessity, the provider says we should be held harmless. We had no idea that there would be a medical necessity issue here, like a lab that's simply doing what it's been ordered to do, didn't see the patient. And so one of the questions that came up is, well, what do we do if we think we have that defense? And CMS said, look, we're the people who decide whether waiver of liability applies. If you think you have that, if you think you've been overpaid, you need to make that repayment. You can't decide for yourself that the waiver of liability is available. What should providers do about that? It's not clear in the reg, but I think it's a possibility that you could make a refund, get an adjustment on the claim, and then appeal that adjustment, and then potentially raise waiver of liability. But all of these kind of subtle operational issues, process issues within CMS, have really not been addressed in the final rule. This is just one of them. Next slide, please. The probe sample. This final rule explicitly allows for the use of probe sample and extrapolation to be used to make a refund. The provider does not have to go claim by claim. However, when doing it, number one, as Katrina said, you don't have to make the refund of the probe sample right away, but you better act reasonably quickly when deciding to do this. But the second is when you use a probe sample, the claims will not be adjusted. It's going to be an extrapolation to the universe, so you will not have, CMS will not have within its system anything to show that the claims have been returned. And so it's important, number one, to keep documentation, as Felicia alluded to, but number two, it also will limit the ability of a provider to have an appeal right because there will not be an adjustment to that claim. Next slide. With respect to appeal rights, the final rule preamble says that CMS thinks it's inconsistent with the concept of a refund to expect to have an appeal right. And that generally makes sense. And then, you know, if you've been overpaid, you got paid twice. The individual wasn't enrolled in Medicare, was enrolled in Medicare Advantage at the same time. Fine, make the refund. But there can be circumstances where an appeal right is absolutely appropriate because there's lack of clarity, and the provider says, well, look, I'd rather not risk a False Claims Act exposure. What do I do? Well, here is where there could be an appeal option because there can be an appeal right from a revised claim, but that wouldn't be available in an extrapolation when there's an extrapolation that's used in the universe. So again, this is another one of these technical process issues that will need to be worked out over time, but could arise in a situation where providers just are not clear on whether there's been an overpayment, could be conflicting MAC advice, could be conflicting obligations depending on where you are in the country. So this is an issue that we're going to be monitoring and kind of that will have to unfold as this final rule goes through the enforcement process. Next, reopening is a kind of a fascinating question. For those who have done refunds in the past, you know that providers have asserted, and CMS has largely accepted, that under the reopening rule, at least on the claims side, that there's administrative finality that occurs after 4 years, and going back 4 years was enough. As we're going to hear about in a second, there's now a 6-year look-back period. And so what's curious is that CMS revised the reopening rule, but all it did was to provide that when a MAC, the rule, as it says here, authorizes MACs to reopen claims related to refunds for a 6-year look-back period. And what it actually says is that if a provider asks for the 6-year look back and wants to make a refund, MAC should accept it. But what's curious about it is CMS didn't address the 4-year period. And I think that the reason they didn't want to expand the 4-year reopening period to 6 years is that I think that would then have expanded the opportunity for providers to seek underpayments to 6 years. And so they've done this curious thing where you have the reopening rule says that claims are administratively final after 4 years, but yet are subject to a look-back period of 6 years. I don't know for certain, but I think the government's position would probably be that the reopening is a matter of rulemaking, and the statute, though, on the look-back period will be superior to any regulation. But of course, the flaw with that is this look-back period is purely regulatory. It's not part of the statute. So this area, again, of reopening is where there's some uncertainty, but there certainly is a mechanism for providers to make their refund on the claim side. What's equally curious is there is no similar provision on the cost report side. There is no mechanism for MACs to reopen or for the explicitly for providers to seek to reopen on the NPR side. So that's where we are with respect to the reopening rule. On the cost report issues, as we said, refunds are due the later of 60 days after identification or when a cost report is due. CMS in the final rule makes clear that that this is very limited. And then we have the issue of applicable reconciliation, that an overpayment doesn't even become an overpayment until after an applicable reconciliation period has ended. And under the final rule, there are only 2 instances of applicable reconciliation. One is an SSI ratio, which determines disproportionate share hospital payments, when that's changed as part of the cost report audit process, or when a provider knows that there's an outlier reconciliation. It's not required to actually make the refund until the reconciliation has been completed. But the outlier reconciliation rule, the regulation is one of the few that provides for time value of money being taken into account in the refund. So providers that think that they're subject to a reconciliation for outliers ought to consider making the refund at the time of the as-filed cost report. Finally, with respect to applicable reconciliation, next slide, is we're seeing that it doesn't apply to DISH, GME, interim payments. Those payments, to the extent that the provider decides that they've been overpaid when they submit their as-filed, those refunds ought to be included with the as-filed cost report. Next slide. And in a situation where we have where there has been a self-identified overpayment, then there could be circumstances where the provider may seek to submit an amended cost report to return to allow for there to be an adjustment to take into account the overpayment. But again, this is one of those technical process issues that are really not addressed in detail in the final rule. With that, let me hand it back to Katrina to talk about the look-back period.
Thank you so much, Bob. So one of the other areas of good news for providers coming out of this final rule is that CMS pulled back from the 10-year look-back period that it had put out in its proposed rule. Those 10 years had been based on the outer limits of false claims act liability, and CMS got a number of comments arguing that the 10-year look-back was inappropriate. And the final rule adopts a 6-year look-back period. And so from the point of identification, you look back 6 years, and all those quantified overpayments received in that 6-year time frame are overpayments subject to report and repayment within those the next 60 days. And now this raises an interesting issue with regard to Stark and the look-back period. This final rule became effective March 14th, 2016. And so for up through March 13, 2016, which was a Sunday, the providers could continue to use the Stark 4-year look-back period that was implemented under the self-referral disclosure protocol. So all the Stark repayments up through March 13, 2016, CMS has stated clearly that those were permissible under a 4-year look-back period. But starting March 14th, so a week ago Monday, a 6-year look-back period applies for overpayments. And the interesting thing here is the self-referral disclosure protocol, as approved, only applies at 4-year look-back, but the overpayment obligation extends to 6 years. And so what happens with the 5th and 6th year back? Well, CMS can't mandate providers to give their financial information for years 5 and 6 because the self-referral disclosure protocol has been approved by OMB with that 4-year look-back. So provider, starting last Monday, moving forward, facing a Stark repayment, has a choice, although it's not really much of a choice. They can either repay or go through the voluntarily provide their financial information for all 6 years, even though it's only mandatory for the 4, and go through the self-referral disclosure protocol for all 6 years and settle all 6 years together, or they can go through the self-referral disclosure protocol for years 1 through 4 and then report and return years 5 and 6 through other means. Of course, that's not much of an option because that would require years 5 and 6 to be reported and returned in full. So the assumption is that providers will mostly voluntarily provide financial information for all 6 years, and it's become a 6-year look-back. This brings us to the mechanics of actually making the report and return of overpayments. The proposed rule contained 13 elements that were to be included in overpayment reports and was fairly detailed as to the process. The final rule dials back from that, and there's no list of reported elements anymore. Instead, the requirement is just that the provider follows a process established by the applicable Medicare contractor. So that can be claims adjustment, credit balance, self-reported refund, or another report and return process from that Medicare contractor. And the exceptions here are the OIG and CMS protocols, the self-disclosure protocol and self-referral disclosure protocol. Providers can proceed through those mechanisms to report and return under the statute without going through the Medicare contractor. And as we discussed before, if you're seeking an extended repayment plan, you must report within 60 days and you must comply with the extended repayment plan. But the repayment doesn't need to be made in advance of that repayment plan within the 60 days. You just need to adhere to the terms of that repayment plan. Of course, though, the report is due even without payment by that 60-day deadline. The one area where the final rule is specific in terms of the content of the report repayment is that a statistical sampling methodology must be, when used to calculate the amount of the repayment, it must be described in the report. And the provider can use a single refund form with an attached spreadsheet of data, but there needs to be that underlying methodology set forth in the report and return for that statistical sampling methodology. Lastly, in terms of who the report and repayment's made to, as I discussed, it goes to the Medicare contractor or under the SDP to OIG or under the SRDP to CMS. Now I'll be sending it back to Felicia to talk about Medicaid.
We've received a couple of questions asking the extent to which the Part A, this rule applies to Medicaid overpayments. And the answer to that, unfortunately, quick and dirty, is we're not sure. We know that the statute, the 60-day report rule return statute, it was self-effectuating, and that it applies to overpayments in both Title 18 and Title 19, which are Medicare and Medicaid, respectively. But CMS has not promulgated a 60-day regulation specifically applicable to Medicaid, and it's unclear the extent to which this would constitute any kind of legal interpretation that might receive some deference in the courts. As I mentioned earlier, there was a Medicaid case out in New York, in the Southern District of New York, called Kane versus Health First. And in that case, the court actually explicitly declined to defer to CMS's interpretation of the 60-day rule, but also declined to simply rely on the state's fairly comprehensive overpayment policies. And so this is still a fairly open area of the law. We don't know for sure whether or not the Part A or B rule will be persuasive authority with respect to Medicaid overpayments. We'll have to wait and see to see what states might do, to see what other courts might do, whether they're going to follow the Kane approach or whether they're going to follow the CMS approach. And so with respect to Medicaid, there are still even more open questions. And with that, I think we move towards any questions, which we have a few of.
Yeah, let me just add one point on Medicaid, but thank you on that. And that is that when it comes to Medicaid, just remember the federal government's interest is a little bit different, because the federal government has the right to recover any overpayment that they think has been made from the state, regardless of whether the state actually recovers from the provider or not. So we're hoping to get some clarification about this, and of course, you know, the Medicaid case generally has to deal with what's going on at a state level, and so it'll be interesting to see kind of where CMS has gone. But at this point, they have not even proposed anything on the Medicaid side. Jenny, do you?
Oh, I think we might go right on. Okay, great. So there are a lot of questions that we're not going to have time to answer. We will get to those answers and make sure that we send those Q&A out afterwards. And I just want to quickly, as a courtesy, let folks who are MediReg subscribers see where they can follow up on today's presentation and get related information from the MediReg site. So in your MediReg subscription, if you take a look at today's What's New, you will see the presentation slides for today. We also have a copy in there of the Health Law Daily report that came out about this exact same rule. And then I just wanted to show you a quick search. I expect that there will be additional information coming out from Medicare and other agencies and organizations related to overpayment. So here's a really great sample search. You can see that we're already seeing discussions about overpayments, obviously in the Healthcare Professionals Manual and the Fraud and Abuse Manual. OIG has issued information. There are a few court cases and even some HPMS guidance on topics related to overpayments. I'm going to store this search on my account, and that's going to give me the opportunity to make sure that the next time a new document appears in the What's New that would match this search criteria, I'm going to get it sent directly to me. So that as the year progresses and we get press releases, fact sheets, manuals, and information coming out from CMS, I will get tapped on the shoulder and find out about those changes right away. And then I did just want to show you how I got to the final rule to start answering some of the questions that were coming up on the call today. I was happy to note the citation was provided in the slides, so I could quickly jump in and get right to that citation and open the rule. You can have this as a PDF if you prefer the newspaper view, but I actually like the text on screen view. And it allowed me to just search on my screen and quickly find the section in the final rule where they specifically do address Medicaid. I know somebody asked that question, and I copy-pasted section 2A, where they said that there is no final rule yet addressing Medicaid requirements, although I heard what you just said about modifying that. There was also a question about the look-back period and whether or not the OMB had been approved. So it was very easy for me to just, right on screen, get right to the answers if they're here. And then, of course, sometimes they're not, and we need to wait for CMS to issue some sort of interesting clarification, and those will be coming out shortly. If you're not a MediReg subscriber and you'd like to take a look at this product, please do let us know, and we're happy to give you a peek. We're going to be sending out the CEUs as well as a thank you for coming to today's presentation in about 48 hours, and we'll be reaching out to you directly if you had asked one of the questions and getting you answers. Thank you very much for spending this hour with us today, and we look forward to seeing you at future webinars. This concludes the webinar. Have a great afternoon.